Welcome to On the Ballot with Ballotpedia, where we connect people to politics by providing neutral, nonpartisan, and reliable information on our government, how it works, and where it's headed.
Hi, welcome back to On the Ballot. I'm Norm Leahy, your host. I'm a senior editor here at Ballotpedia. Joining me today, I'm very excited about this guest. This is going to be a fun discussion. Is Sai Prakash, who's a James Monroe Distinguished Professor of Law at the University of Virginia Law School, and quite an expert on the presidency, presidential power, written a couple of books on the topic. Sai, welcome to the show. We're so excited to have you here.
Great to be with you today.
And you are one of those folks, legal scholars, who's called an originalist. Can you give us the elevator pitch on what that is?
Well, originalism is a theory of interpretation that says that we should understand the meaning of laws by reference to the meaning that they had at the time of enactment. So it stands in opposition to the idea of living constitutionalism or living statutory interpretation, where judges and officials of the government are supposed to vary the interpretation over time to meet new situations and unforeseen circumstances. So it's a more historicist approach and a approach that's less concerned with trying to match or fit the Constitution to whatever we think might be best for today.
Which is an interesting perspective, considering that today presidential power is very much in the news. But if you think about it, even for a few minutes, presidential power, the limits and extent of it, had been in the news almost before the ink was dry on the Constitution. Take us back. When the Constitution was being put together, what was the vision for the presidency?
Well, at the convention in Philadelphia in 1787, there were fierce debates about what type of executive we would have. Was it going to be a plural executive or a singular executive? If a singular executive, was there going to be a council attached that the president would have to run all these decisions by the council? And then what particular authorities would the president have? Would he have a pardon power? Would he be commander in chief? Would he be able to appoint? And of course, there was questions about how do you select this person? Is there going to be a national popular vote? Is it going to be selection by governors? Are there going to, just all sorts of questions. And that finally got settled in a sense at the convention. They produced the draft constitution. Article 2 lists a bunch of, authorities and the way that we pick our president, at least the initial way we picked our president. That was then sent to the states to ratify or not. And there were fierce debates in those states about the Constitution, but about the presidency in particular. And there were many people who said this president resembles a king in all but name only, right? That is to say that if you look at this president compared to our governors or our state executives, this person has far more authority and kind of looks like the English crown. And they were great.
It's interesting that we're both in Virginia. Governor of Virginia, his technical title is His Excellency. So that's a thing that it's an odd holdover from that time. But I wanted to, in the prep for the show, I was looking at something. I was looking at a political cartoon, and it had a picture of the president dressed as a king, crown, robes, scepter, standing on a shredded Constitution. Born to Command was the headline, but it was from 1832. The president was Andrew Jackson. So we really thought and had this tension about, are they really kings? Do they act like them? For a long time.
Yes, I mean, it goes back to Washington. People accused him of trying to aggrandize the office. And of course, he was to my mind, a very selfless person and wasn't really interested in, trying to amass power. I mean, he could have run for president until he passed away. He decided to step away. So he was the antithesis of all that. But nonetheless, whenever he took a decision that was controversial, there were claims that he was acting like a monarch. It's kind of guaranteed that will be the claim because, of course, the Constitution vests a lot of authority in one person, and that naturally brings to mind monarchical government.
And then talk about how over time, the power of the presidency does seem to have expanded, if not, in fact, certainly in perception. So that by the time you get to, say, 1973 and Arthur Schlesinger coins the term the imperial presidency in reference to the Nixon administration. Has it become far more than it was intended to be?
There's no doubt in my mind that that's true. The presidency was mainly a law execution institution. We have three branches. One makes the laws, one executes those laws, and one adjudicates disputes about their meaning. And we all know what those three branches are. The president was supposed to be that second branch that executes the laws. Of course, the president would have authority as commander in chief to lead the troops when Congress created troops and when Congress declared war or when Congress wanted the borders defended, as they always would want them. And the president had a pardon power, which was certainly significant. But early on, the president started claiming a popular mandate. Andrew Jackson, who you mentioned earlier, claimed a popular mandate to war against the Bank of the United States. And people mocked the assertion that he had been elected to, curb or destroy the bank, because they said, well, that's not how people vote. People vote for one candidate over another. They don't mean to endorse everything that the candidate stands for. It is a choice amongst two people, sometimes a choice amongst, the lesser and the more evil. But nonetheless, he claimed it. And ever since, presidents have been claiming a mandate. And of course, part of that turns on another sort of innovation, which is presidents now run on campaign platforms. There were candidates in the 19th century who said, I'm not going to debase myself by making promises. You should pick me or the other person based on our resumes. That is no longer possible, right? We expect all kinds of promises from our presidents, and they relate to things that the president has no direct control over, like legislation, right? The president cannot pass legislation. But it turns out when you make promises about things that you can't control, over time you seek to control that which you could not control before. And so, of course, we're now seeing presidents grasp in areas where they didn't have any constitutional authority 60 or 70 years ago, and they certainly didn't have it at the founding, but they want to have it now to fulfill their promises.
But part of that is because Congress has ceded power to the executive. Is that correct?
It's certainly the case that Congress has long delegated authority to the president in express statutes. That is to say, Congress clearly means to give the president more authority. And that itself is problematic in various respects. But on top of that, presidents now read statutes in very aggressive ways, in ways that Congress wouldn't have contemplated in order to achieve their legislative ends. And we've seen, the last several presidents doing that for their, political purposes. They run on a platform of, say, building a wall or doing immigration reform or student loan relief. Congress doesn't ratify them by passing a statute, and then they just do it anyway, reading some old statute as if it gave them the authority that they had just sought from Congress, which is a little incongruous, but apparently not enough to stop them.
Well, thinking of old authorities that presidents tend to use, presidents like to declare emergencies to enable them to to bypass the legislative process in many cases. How many active emergencies do we have right now? I've lost count.
I haven't looked in a while, but I've heard maybe 50 before Trump, and I don't know how many he's declared since. But you're quite right that the presidents are declaring emergencies left and right.
And some of those emergencies go back for decades.
I think the oldest one that I recall is about 40 years old, which casts doubt on the question, or casts doubt on the premise that there really is an emergency, because if an emergency always exists, it seems to it seems to negate the idea that there's something emergent, right? It's not emergent 40 years later.
Yeah, it's part of the word. It's strange how that works. But it's not just that. It's that in things like following Watergate, for example, Congress reasserted itself. We're going to pass all these laws, War Powers Acts, the Budget Act, certain things that to reclaim, at least in part, some of Congress's prerogatives under the Constitution. And there was, at the time, tell me if I'm wrong, there was some worry that we were sort of neutering the presidency. It would no longer be the same. That didn't last very long, did it?
Well, there definitely were people who saying the presidency has been grievously weakened by Congress. And part of their claim was that some of these statutes were unconstitutional. And of course, if you think that, then you think you are weakening the presidency. Other people disagreed with that claim that these were unconstitutional, but whether they were constitutional or not, their effectiveness has gone down over time. We're back to the days of the imperial presidency and then some. I mean, what Schlesinger described in 1973 is dwarfed by the presidency of today. It's not, there's no comparison because Schlesinger was mostly focused on war powers. Presidents still claim the authority to take us to war. On top of that, they're legislating in all sorts of different ways and then also choosing to ignore statutes. So they're both creating new law and ignoring old law in a way that Schlesinger couldn't have contemplated.
Well, the part about war is that the last war that we declared, Congress declared, was the Second World War, correct?
So that's what's commonly said. The last formal declaration of
Formal
war
declaration.
was in the, there were five formal declarations of war in World War II, and there hasn't been a quote formal declaration since. But that's a misconception in the sense that whenever Congress authorizes warfare, it has declared war. The declare war clause does not require particular words to use it.
Okay.
Right? You don't. It's not a magical magical incantation. If Congress says the president must go to war, that is a declaration of war. And if Congress authorizes the use of military force, as they did in 2001 and 2002, that's basically a use of the declaration of war power. And I think a focus on whether they use the words declare war, I think, kind of misunderstands what Congress is doing and what the president's doing. In point of fact, when the president takes us to war unilaterally, he is declaring war, as the Constitution uses that phrase, because going to war was understood as declaring it in the 18th century.
You mentioned the 2001, 2002 authorizations for the use of force. Those are still on the book. Those are still active, right?
They are still active, and most declarations of war that we've enacted, I think maybe all of them, none of them have come with a deadline. What's odd is that Congress hasn't chosen to repeal them. I mean, the war in Afghanistan is over. Obviously, it was partly against a war against not only the Taliban, but Al-Qaeda. But Al-Qaeda, you might think, is decimated as well. Saddam Hussein has been dead for years. But that 2002 AUMF was used to attack ISIS and other elements in Iraq. And so, the statutes have been repurposed by the executive to do other things.
And there are, obviously, you would know this as a law professor, that a lot of court action has been used of late and in years past to try to tamp down, moderate, if not outright stop, some presidential actions, be it whether those be executive orders or whatnot. And the current Supreme Court recently has given the president recognized that the president can fire the heads of independent agencies. And so, and there's also, along with that, a debate in Congress and elsewhere about whether there should be limits placed on how far courts can go along those lines, such as issuing national injunctions or whatnot. So I guess what I'm getting at is, are we approaching some sort of real tension point on these issues of not only executive power, but congressional prerogative and the role of the courts?
I mean, Congress has basically rendered itself somewhat irrelevant, right? They pass an annual budget every year, but that is like pulling teeth. And it's usually a continuing resolution, which just repeats what was done the previous year. So there's not much independent thought in the entire budget. They negotiated a couple of things with the Congress and the president, and the rest is just repeated. And then they're not able to pass new legislation because the parties are so divided, and there's so much, partisan disputation in Congress. And of course, they're willing to invoke the Senate filibuster to prevent legislation from passing. So Congress is sort of kind of out of the business of legislating. It certainly can't stop the president. It can only squawk. Right there, President Trump was impeached twice, but it had no discernible effect on what he was able to do the first time, and the second time he was essentially out of the office. So Congress isn't able to check the president, and then the courts are able to check the president because the president remains willing to enforce the court's judgment, particularly the Supreme Court's judgments. And you're right that there's an ongoing dispute about the extent to which one judge can impose an injunction on the executive's activities nationwide when the parties, aren't a class action. And I suspect that the court will strike that down. But the justices, I think, expressed a good deal of unease with the state of our separation of powers because they too see the executive branch adopting aggressive interpretations of statutes, and in some cases, the Constitution. They know that Congress isn't up to the task of checking the executive anymore. And they think that the courts are the only ones to do it. And what happens if you have to go to a court each time the executive branch does something wrong? Obviously, some people can't afford to go to court or contest it. And it might take years for the Supreme Court to get involved and render a judgment that the executive would then honor. So there's a structural problem there, even if you think that the lower courts are wrong to issue a nationwide injunction.
So, I know that predicting the future is always fraught, but we're at a moment in time where it seems like we are going to head towards an increasingly strong executive, irrespective of which party holds the office. All of them seem to be jealous of the power that it has and increasing it. How do we, I mean, we should be concerned about that, right?
Oh, I think we should be very much concerned. I think constitutional or statutory reforms are in order. In my 2020 book, The Living Presidency, there's some reforms discussed there that Congress could enact. But I think, constitutional reforms are in order as well. It'll obviously be hard to pass because presidents don't want to see their authority diminished, but you don't have to present an amendment to the president. You can make it prospective so it doesn't apply to the current occupant and therefore doesn't necessarily reflect upon them. It just takes, it takes some courage on the part of Congress to talk about reforming the presidency while there's a sitting president of their same party. Obviously, Democrats are going to be more willing to talk about this now than they were in the last administration. But there's a golden period, a golden hour, if you will, at the end of a presidency, maybe the last year of a presidency, where you can talk about reform. And even though it might be perceived as reflecting poorly on the incumbent, I'm not sure. You could easily say, you're great, President Trump, but we need to reform the presidency going forward. And because he has no formal role, it's not obvious that he would mobilize against it. Because I'm not sure that any of them are really concerned about the presidency long term. They're really just interested in their own policies and preferences. And so they're not interested in expanding the presidency for its own sake. They're interested in expanding the presidency for the instrumental purpose of advancing their policy agenda or advancing their chances of getting reelected.
All the more reason to have vigilant and informed voters because ultimately the check is ours, isn't it?
That's right. That's right. But, of course, lots of presidents run saying that the incumbent has abused the office. And then, unfortunately, they end up doing the same thing. In fact, sometimes the exact same thing that they had decried. And this is common. I think Obama did this with Bush and Trump did this with Obama. And then Biden did it with Trump, and now Trump will do it with Biden. It's inevitable because they don't really mean what they say. And then, of course, even if they did mean what they say, they see some situation that they believe cries out for action, and they are the man at the helm who will take the action. And they don't want paralysis within Congress to stymie their desire to take action.
And on that happy note, we have to come to an end. Sai Prakash, professor of law at the University of Virginia Law School, I appreciate you taking the time to join us today on the ballot to discuss these issues. I want to talk to you again at some point about reforming the Supreme Court. So I hope we can have that talk soon.
Well, sure. Let me know. I'm glad to have the chance to chat with you today and your audience.
Sai Prakash, thank you for joining us. And for the rest of you, you can look for this edition of On the Ballot wherever you get your podcasts, Spotify. You can even see us on YouTube. So until our next episode, which will be coming to you soon, I'm Norm Leahy. We'll be joining you until then in the digital pages of Ballotpedia. Take care.